voudrais commencer par remercier le professeur Gramont de cette introduction que je trouve très généreuse. J'ai pensé qu'il parlait de quelqu'un d'autre. Mais, et aussi de votre introduction à vous, Monsieur Paris, auparavant. Mes remarques vont être en anglais parce que c'est comme ça que je les ai pensées, mais s'il y a des questions, je comprends encore assez bien le français et puis je vais faire des efforts pour vous répondre. First of all, I'd like to clarify one thing. I don't represent the ICC, and I'm not an insider. I left the ICC almost 5 years ago, so I look at it with some distance. A speech I would have made 5 years ago would have been very different. The other preliminary remark I would make, which is substantive, is that the first responsibility for all crimes, including international crimes, including the worst crimes, always belongs to a state. And in an ideal world, there would be no need for international justice at all. International justice was created to compensate for the failures of national systems precisely because it is when the worst crimes are committed that states often are unable to deal with them, either because they are party to the commission of the crimes, or because the structures have become so weak that the system simply cannot absorb national justice. And then in that sense, the creation of the ad hoc tribunals by the Security Council first, and then the ICC, were major accomplishments. So I'll go through the ICC in 3 parts. One, a few words about its creation, several words about its creation, something about its accomplishments, and then the bigger part, the challenges. Now, the creation. If you look at history, let's start with Nuremberg after World War II. Immediately after that, there was a movement to create an ICC. The International Law Commission started working on it. And then the whole process was stopped for 50 years. Why? Largely because of the Cold War, because the superpowers could not agree on anything, let alone international justice. So we skip 50 years, and we get to a new situation where this institution gets revived. Why? Well, when a new institution is created in international law, it's always because there has been a shock somewhere. And in that case, the creation of the ICC was made possible by 2 developments. One, the end of the Cold War, because at the time, I remember I was at the UN, Russia was most Western than the West. And because of the crimes committed in Rwanda and the former Yugoslavia, which really created a shock wave in the international community. So in 1998, the Rome Conference is convened to create an ICC. It does, and at the time everyone was thinking, well, the optimists were thinking maybe 10 years, the pessimists maybe 25, or perhaps for another angle of optimism, some people were thinking never. But it was created. It was created with 60 ratifications, and so the court has been in operation this year for 10 years. There were certain things on which states agreed. They agreed that they were tired of creating ad hoc tribunals or even hybrid tribunals when crimes were committed. You needed an institution that would be permanent and that would be ready to deal with crimes, major crimes when committed. They hoped that there would be an effect of deterrence for the commission of future crimes, and that there would be a positive effect on peace and security. The other thing that everybody agreed on was that this court would only act if a national system was, to borrow the words of the Rome Statute, unable or unwilling genuinely to carry out the relevant investigation and prosecution. So contrary to the ad hoc tribunal, which had priority over the national systems, the ICC could only act if the national system did not. That was those were the points of agreement, but they were major points of disagreement. The states were divided between those who wanted an independent court, a strong court, and those who wanted limited jurisdiction or real political control over the court. I'll give a couple of illustrations, but here I'm going to be careful because I thought I was going to speak to students and academics, but as I arrived in the room, I realized there were witnesses. So I can't just say anything anymore. I really have to stick to what reality was. In my mind, the states were divided into three groups, and I'll stand to be corrected later if you think I'm wrong. The vast majority of states were in favor of an independent and strong court, the vast majority. Then you had the P5, the five permanents of the Security Council, which did not like so much a very independent court and certainly wanted strong control of the Security Council over the court. And then you have other states which detested the thought of an independent court and also detested the Security Council. So that things got a bit complicated there. And for example, those states did not want the court to deal with internal conflict, which was paradoxical because the court was largely created because of the atrocities that were committed in internal conflicts. So it was complicated. It was complicated, and even though the negotiations were going fairly well on most issues, they were not going well at all on jurisdictional issues. States were not negotiating, they were repeating statements after statements, always the same statements. And that was very frustrating. And then you had the NGOs. The NGOs, which played a major role at the Rome Conference by educating small delegations in particular, and also doing a little bit of lobbying on the side as well. And the NGOs were coming to me and were saying, go for a vote. What are you waiting for? You sissy. You can win. They were having polls. And the Secretariat was having polls, the UN Secretariat was having polls too, and they coincided. You knew, for example, there were 84% of states in favor of universal jurisdiction. Many, many states, the vast majority in favor of an independent prosecutor and all that. And I always said no. I'm not going to vote. Now, why? Because we figured that, for two reasons. One is technical. If you vote on Article 5, and then you arrive at Article 57, and you realize there was a link with Article 5 that you had not seen, then you were dead because you could not go back on something that had already been voted upon. But the most important reason was that the court could not be strong only through its provisions. It had to receive enough support to enter into force. And to achieve that, you had to accommodate a much bigger group of states than just the majority that wanted a strong court. And so this explains the outcome of the Rome Conference. It deals with the most serious crimes, mainly crimes against humanity, war crimes, genocide, with the aggression being a special case. There's no retroactivity. There's no universal jurisdiction. You need, for the court to exercise its jurisdiction, you need the consent of the state where the crime was committed, or the territory where the crime was committed, or the state of the nationality of the accused. And those of you who are lawyers and who know criminal law will recognize those are the standard basis for jurisdiction. The Security Council can refer situations to the court, but it's not the only way of triggering the jurisdiction of the court. The Security Council can ask the court to suspend proceedings, and I think the spirit of that provision was that the court would have to follow suit. The prosecutor can start or may start an investigation in a situation that has not been referred to by a state or the Security Council, but that is subject to the consent of a pretrial chamber. So in summary, there are 3 triggers possible to get into the court to exercise its jurisdiction: states, Security Council, prosecutor. So that was the first set of nuanced provisions that did not meet the requirements of these idealists, which wanted a very strong court. But even to this day, I think it's more or less okay. I don't feel bad about the balance that was achieved there, but I do feel bad about the next thing. And the next thing concerns the functioning of the court. Here you have 160 states that see a court being created without having any idea of what that court is going to do. You knew the Yugoslavia Tribunal dealt with Yugoslavia and Rwanda Tribunal with Rwanda, but you didn't know what the ICC would deal with. And so, since everybody agreed that this court should not be political, could not be political, it had to be a real judicial body, it also had to behave in a very predictable way. Unpredictability in situations had to be compensated with predictability in its behavior. And so the result of that was the states created an unbelievably lengthy, detailed procedural statute in a vacuum, because you didn't know how the system would operate. And when that was done, they were not content with that. They thought, we're going to put another straitjacket, which is to raise the bar for changes to unbelievable levels. So if you want to make a substantive amendment to the Rome Statute, you have to have a vote of 2/3 of the state parties. That's not unreasonable. But then for the amendment to enter into force, you need 7/8 of states having implemented that amendment in their internal legislation. Well, welcome 22nd century. And now, of course, that the court is operating and that states see how many of those provisions don't work, they can't change them. They have created their own jail. Oh, that's a bad word in that context. The other problem, of course, that probably was inevitable, is that the whole system is based on cooperation. There's no real, there's no executive arm that is really worth mentioning. The Security Council could do that, but it certainly has not yet. So all those features I just described have consequences following us today. Now, development and achievements. From 60 ratifications in 2002, we now have 122. Some continents are well represented. Africa has the most ratifications, 34. And then you have Western Europe, Eastern Europe, the West generally, minus rather big states which will remain anonymous. Latin America, number of states. Fewer in Asia, and very, very few in the Middle East and North Africa. But that said, it's still not so bad. 122 states that have ratified are more than the number of states that voted for the statute in Rome. And to take another comparison, which I think is more telling, the International Court of Justice has existed for 60 years and has followed its mother, the Permanent Court of International Justice, adding a couple of decades. The number of states that have accepted the obligatory jurisdiction of the International Court of Justice is about 66. 66, 122 in 10 years. It's not so bad. So the level of acceptance, which should aim at being universal, is fine today, is okay today. And then you get into activities. before getting into activities, I have to explain that, again, if you compare with the ad hoc tribunals, you go to the ad hoc tribunals, you have the situation that has been defined, say former Yugoslavia, and then you have cases against individuals. The ICC does not work like that. You have to have two steps. You first have to have a situation going to the ICC to be accepted by the chambers. Prosecutor or someone brings a situation before the ICC. It has to be accepted by the chambers, and once that has been done, and that of course implies, for example, that the state is unwilling or unable to deal with those particular crimes, those kinds of things, which are not necessarily easy to determine. After that, once the ICC has accepted those situations, then you begin cases against individuals. You now have 8 situations before the ICC. Uganda, the very first one, Uganda, Democratic Republic of Congo, Central African Republic, Darfur in Sudan, Kenya, Libya, Côte d'Ivoire, and Mali. Of course, what is common among all those situations, they're all in Africa. Of those situations, 4 have been brought before the court by the states which had situations to be dealt with. 2 have been brought before the court by the Security Council, and 2 by the prosecutor with consent of the chamber, the pretrial chamber. Within those situations, you have now 18 cases for 25 persons. Most of those persons have been the object of arrest warrants, some to summons to appear, some have been executed, a few have been withdrawn largely for cause of death. You have some people who are detainees in the court. And now, in the past few days, there has been another series of developments, which is that now people have been arrested not for committing crimes, but for exercising influence on witnesses, which is administration of justice. And that is very, very recent. We'll see how it is. So, to sum up, this court is a busy court. They really do work a lot. Now, you have another angle to that, which is called the situations under preliminary examination by the prosecutor. Those situations are not before the chambers yet. The prosecutor receives information from a variety of sources that have to be credible, and then looks whether a situation should be dealt with by the court formally, by the chambers. Those situations under preliminary examination are not limited to Africa. I think there are only 2 in Africa. You have 2, a couple in Latin America, Honduras and Colombia. You have Korea. You have a Comoros case. Why Comoros? Because these were ships of Israel, and so the court could have jurisdiction through that state party. You have Georgia, Russia and Georgia, and you have Guinea and Nigeria. So you have all those 8 situations. What the prosecutor tries to do in those cases is not to bring those situations before the court, but to get the states involved to exercise their jurisdiction. So that the court does not have to be involved, which is the logic of the Rome Statute. So those are the mechanics of what is happening before the court, but you have also something else about the court, which is its broader impact. The court, I think, is now well established on the international landscape, with problems. We'll see that in a few minutes, but it's not going to disappear. It's there. In a few decades, it will be as natural as the International Court of Justice is now. Many references are made to the court as soon as serious crimes are committed anywhere in the world, and the court has an important impact on national systems. National systems try to adopt legislation, for example, that does not put them accidentally as unwilling or unable to deal with those crimes. The states also adopt legislation that allows them to cooperate with the court. But even states that are not in the ICC system have borrowed the content of the Rome Statute in substance and put them into their legislation because it is the most recent consolidation of what can be said about the most serious crimes. That was the nice part of the story. Now I get to my third part, which is challenges. And here, to simplify, I'll deal with that I'm going to have two issues, but each issue will be developed. The first one is efficiency. Is the ICC efficient? The answer is no, it's not efficient. In 10 years, you have one conviction, one acquittal. Of the arrest warrants that have been issued, 12 are pending. You have no arrest warrants executed in Sudan, Libya, or Uganda. You have some missing in Congo and in a variety of situations, Côte d'Ivoire, all that. Okay, so that's a fact. Now, why is it that way? Why is the court not efficient? There are reasons for which the court is really not responsible. The first one is that as soon as the ICC deals with something, it is an awful situation. It's an environment where crimes continue to be committed most of the time, where there is a conflict, international or non-international, and that, of course, complicates enormously the work of the prosecutor or of the registry, for that matter. That does not work. That's very. They have offices in a variety of countries, but sometimes those offices have to be closed for a while because it becomes too dangerous. The investigation have to be pulled out. All those things. These are dangerous situations. You have to protect witnesses and victims and the staff. So those are problems which slow down a lot of proceedings, but for which the court is not responsible. Then you get into what I was discussing earlier, which is the complexity of the system. And I'll mention only two things. One is the participation of victims and reparation to victims. From a humanitarian point of view and from the future of justice, it is a very good development that victims can unload, can speak before the court. But the role of victims was defined very loosely in the Rome Statute. So I remember when I was a judge on the appeals chamber of the court the first year, I think most issues coming before the appeals chamber in interlocutory appeals related to what are exactly the rules for participation of victims. So that slows down. The other thing is the creation of this pre-trial chamber before the trial. Why was it created? Because of Yugoslavia. The pre-trial chamber was created because the Yugoslav tribunal, which did not have a pre-trial chamber, realized that there were masses of issues before the trial chamber that had nothing to do with the determination of the guilt or innocence of the accused. And so, in their wisdom, the states in Rome said, we're going to fix this, we're going to create a pre-trial chamber. What does it do? It decides on jurisdiction, it decides on admissibility, it decides on arrest warrants, it decides on confirmation of charges, and in some cases on protection of evidence and all that. The problem is that different judges in the court, coming from different systems, don't have the same view of what the role of that pre-trial chamber is or should be. Some think this is only a chamber that renders decisions, and then say the prosecutor continues its work on the basis of those general decisions. Other judges think that it's a bit like a juge d'instruction in France, where that pre-trial chamber is entitled to tell those prosecutors, this is what you do in detail. there was a big case on this in the past few months, which was in favor of an active role of the chamber of deciding also, that's another issue, the standards of proof. The standards of proof were deemed by some at the pretrial chamber to be much too high, because they were requiring the prosecutor to bring evidence that was akin to what is required in a trial, as opposed to what is required in pretrial proceedings. So none of that is settled. The pretrial chamber role is not settled. And then comes the human factor, because normally things go bad also because of humans. Judges. The judges I'm not going to comment a lot on judges because this is being taped, but one thing that a lot of judges do not do is to allow their decisions to go to the appeals chamber, because they don't like that. They think, we know, the appeals chamber is only going to undo a perfectly good decision. The result of that, when you come to interlocutory decisions, is that everything remains in limbo. You have a series of different chambers deciding in totally different directions without any coherence that the appeals chamber could provide. Now, this is going to end, because at some point you've got the final appeal, and then the appeals chamber will rule on everything. But in the meantime, you have all those issues that are fundamental for the functioning of the court that are not settled. And someone was telling me the other day that the judges in pretrial and trial chambers are particularly reluctant to allow leave of appeal, to grant leave of appeal, leave to appeal, when it comes to constitutional issues. As long as it's not important, it goes. But when it is, forget it. And then there are, of course, other issues. The defense presents too many witnesses and takes an eternity to go through them. The prosecutor has, or had, levels of standard of proof that were erratic, too much evidence which has not been really sorted out. The chamber has to go back and say, no, you do better, for all those things. So what can we do about this? Amending the statute? Impossible. So the chambers are working, the chambers and the prosecutor are aware of those problems. The chambers are looking at amending the rules of procedure and evidence, which would be a way of improving the situation. They look at efficiency, they look at ways of shortening the length of proceedings, and all that. Obviously, the fundamental issues such as the role of victims and the pretrial chamber has to be settled at some point. And the OTP, the prosecutor's office, is also aware that their old methods have not always worked. They're trying to improve them, and they have asked the Assembly of States Parties for a real change, which is give us 10 more million euros. But they're right. The prosecutor is right. Because the first prosecutor thought, honestly, that he could do a lot with very little. Well, he could not do a lot with very little. At the time, it would have been the time to ask states, give us money, because states were all enthusiastic about the ICC, and there was no economic crisis. Now the situation, this is different. The prosecutor, the second prosecutor is now asking for that money, but whether it will come or not is another issue. And the prosecutor needs that money. So first challenge, efficiency. Second challenge, politics. The environment of all international tribunals of that kind is political, all of them. The ad hocs, the ICC, the hybrid tribunals, Lebanon, Cambodia, it's all in a political context. But the ICC is particularly affected because the scope is so much broader. Every time the ICC starts a case, it offends someone else. So this complicates its life. The first political difficulties were with the United States, but now it's over, really. The first administration, Bush, was no fun to deal with as a president, let me tell you. The second Bush administration was already better. It was understood, first of all, that the court was judicial, did not have political goals, was not determined to attack the United States at every corner, and that the court could in fact be useful for political objectives that the United States had. So I remember during the second Bush administration, we would meet with American officials. We would wear a false nose and mustache and never be seen in public or anything like that, but the meetings would take place, and it was working. There was an element of cooperation developing. So, of course, it continued under the Obama administration, but in all fairness, I just wanted to say it did not start there. It started earlier. So, let's forget about that. Now, Africa. This is much more complicated. You saw that all proceedings were in Africa now. It's simmered for a while, but let's take Kenya as a case study. The president and vice president of Kenya were the subject of arrest warrants before they got to their functions, to those responsibilities. Then they were elected, president and vice presidents. First of all, the Kenyan parliament was not too happy that those the ICC proceedings were continuing, and passed legislation to withdraw from the statute. It's not binding on the government, but that was done. Then there was lobby for suspension of proceedings or end of proceedings. Then there was the AU summit, the African Union summit. Some African states, which particularly detested the ICC, were hoping that this summit would lead to mass withdrawal of African states from the system. It didn't happen because the African states are not a monolith. You have some which are really against the ICC, but others which do not want Africa to withdraw. So there was a complicated game within this summit, and the result of that was an agreement that the AU would use various channels to seek to end procedures or suspend procedures against those two persons. The African Union wrote to the presidency of the court and said, could you please ensure that this nonsense ends? The presidency, of course, said, I'm sorry, but we're just managing this court. You have to go to the chambers for this. Okay. So the EU goes to the UN Security Council to end procedures. The Security Council, for one in its life, takes a decision, and that decision is not to allow the end of procedures. Listen to this, the vote. 8 votes in favor and 9 abstentions. Isn't that great as a way of taking decisions? So the African Union, not too happy about that, writing, we now know who are our friends and who are not, decided to go to the Assembly of States Parties, which is now in session. Its session started a few days ago, and it's now in session. And I think overall what they want is probably, because this is not over, probably an amendment to the Rome Statute exempting the heads of state from the jurisdiction of the court, and the possibility for the current, the president and the vice president of Kenya, to not to be obliged to be present all the time, to find ways of allowing their participation in proceedings without being physically present. The second point to me is not unreasonable, because when you have a head of state, you do have a job. And if you spend all your time in The Hague responding to criminal proceedings, your job is made a lot more difficult. And I hope that on that point, There was talk about video link, for example, instead, or partial attendance at certain key moments. I hope there will be a solution to that, because it should be possible. But the other point is a lot more difficult. If you exempt heads of state from the jurisdiction of the ICC, that goes to the core of the reason why the ICC was created. And so I don't think there's a hope in, snowball's hope in hell that this will be accepted. So I don't have a crystal ball, and I don't know what's going to happen, but this is the issue as it stands now. As an appendix to this, I should say that the problems of the court in Africa did not start with Kenya. Of course, when an arrest warrant was issued against President Bashir of Sudan, that also created a shock, and also created a shock in the African Union. But even that was not the first thing. There were problems already in Uganda. The issue of peace versus justice. Is it a good moment to have criminal proceedings when you're trying to get people to surrender to the government, things like that. And to come from sublime to the ridiculous, my role, the court had an agreement with the European Union, which was a fairly good agreement. The court very much wanted to have an agreement with the African Union because all situations were in Africa. And so the court goes to the African Union and says, this is the agreement we have with the European Union, could we do something like that with you? And the African Union says, agreement, we don't really like that, we would prefer a memorandum of understanding. The court, flexible, under my presence, said, fine, let's have a memorandum of understanding. We go with this memorandum of understanding, and the AU say, we don't like this one, that provision, the other provision. The court says, fine, we remove those provisions. To this day, there's still no agreement or memorandum of understanding or anything like that with the African Union. So there's something deeper than just specific situations creating problems. There is something deeper there, and I'll leave it at that. Now, what are the arguments? The arguments are interesting because they're not legal arguments. They're political arguments. Argument, the court is a tool of Western states. It was created by whites against Africans. The African countries are targeted because of racism, a desire to destabilize Africa, and choose regimes that favor regimes that are favorable to the West, and try to weaken regimes that are not favorable to the West. There are counter-arguments because, again, I'm here only talking about African speaking, not me speaking, African speaking. When this business came up with the AU, you had a strong reaction from many people, for some states, Senegal, Botswana, but the civil societies, the civil NGOs got together and said, we can't do this, we can't withdraw from Africa. Kofi Annan spoke about this, Desmond Tutu. Desmond Tutu, I think, put it probably the best. He said, the court is not against Africa, the court is against impunity. And then there are other arguments. The one which is really, really absurd is that the court was created against Africans. Because, and here I'm my own witness, and the other witnesses will corroborate what I'm saying. The region that wanted the court the most was Africa. Because when you come to, say, the West or Latin America, it was a combination of humanitarian concerns, of geopolitical considerations. In the case of Latin America, let's not go back to what we knew, but it was more, it was really for the future. The Africans did not see the court for the future. The Africans saw the court for now. They were thinking this court is going to discourage our neighbors from sending criminals and do bad things to us. So the most vibrant statements I heard in Rome came from Africans, saying we need this court and we need a strong court. So, and after all, 34 states, 34 African states are parties to the statute, the biggest bloc. And 4 referrals were brought to the court by state, by African states, not by the Security Council, not by the prosecutor. So that argument really I would dismiss. And then, of course, you have the more general arguments that the crimes that are committed in Africa are very grave. They're committed in internal political crises, non-international conflicts, international conflicts. Classically, the situation where governments are the least able or willing to deal with those crimes. It is also said, of course, that why don't you put your act together? If you have a national system that works, the ICC will not take the case. It will withdraw. I'm trying to spare the very details here to end one day. The last point on that, no, the second last point on that, is that there was a poll in two polls in Kenya in the past week. The first poll was, do you people want the ICC to remain involved in Kenya? The poll was 51% for. Of these 51%, 40% thought that this is the best way of bringing justice to victims. 24% were saying we don't trust our courts. And the rest was, it's important for the ICC to continue to work for the future of justice generally. That was the first poll. The second poll was about another issue. The second poll was, do you people want your president to attend ICC proceedings? And the result of that poll was 67% in favor. Now, this 67% in favor was in part because they thought he will clear his name then. But this poll in Kenya is not entirely consistent with a broader position that the ICC is a bad thing. Now, to be fair, and here really comes to the last point on this issue, to be fair, there are two questions that are awkward. One, the first is, why do we have only African situations, like crimes were not committed elsewhere? And the second is, why among the people who are brought to the ICC are there so many in the opposition and so few in government? Now, I'm going to try to imagine what the prosecutor would say to this. This is hypothetical, right? It's not reality. The prosecutor would say, well, first of all, we can't deal with certain things. If something happens in Iraq, and you don't have any of the people involved in Iraq having ratified the ICC, the statute, and the Security Council does not obviously get involved, then the ICC is institutionally, constitutionally unable to act. And I think it has to be that way. I think that the ICC cannot, should not ever go beyond its mandate just because it's convenient, because then it becomes a political creature. Then the prosecutor would continue to say, in my hypothesis, my imagination, that the court, the functioning of the court is so dependent on cooperation by states that you have to start somewhere where that cooperation is obtained. That if you choose the wrong target too soon, then there will be no cooperation from the state and there will be nothing at all. And so, my imaginary prosecutor would say, we're going to go in sequence. We're going to deal with everything, but we're going to start with what is feasible and what is attracting our cooperation, and then we'll see how it develops. Of course, having been both a judge and a diplomat, what floors me in all this debate is how totally blurred legal and political are. I don't think it's accidental, but you have moves made by certain people to other people, knowing full well that those other people cannot and will not will deliver. And so you have more and more agitation, more and more feeling that the whole system is unfair, and why do we stay in it? Just for the sake of peace, let's imagine that what I just said is what was said by the prosecutor. Now, by way of conclusion, even with improvements, even if the ICC had no political problems and functioned incredibly well all the time and had efficiency throughout, it would still never be able to deal with more than a handful of cases for question of resources. And that has to be accepted. And so then we have to look at the broader picture. The good aspect of international justice is pressure on national systems, the normalization of international criminal justice from international to national, the development of domestic legislation, the development of jurisprudence, the development internationally of a body of prosecutors, investigators, NGOs, which then can go back home and help the development of a national system. I have not really overloaded you with quotes, right? So I'll give you one. An author wrote recently, the international institution's most effective role is to enhance the prospects of domestication of international criminal justice by acting as a catalyst and by providing technical assistance and support. The international criminal justice will always be a tortuous and a painstaking path consisting of the mutually reinforcing and complementary process of justice at international and national level. The same author makes a comparison which is more vivid. He says, it's like, you have building blocks which are asymmetrical. They come with no particular order, but in the end, it may form something. So the process is unorderly, but it will eventually lead somewhere because the tendency is to go closer. It's not to go wider. And so perhaps one day the international criminal justice will meet its goal of prevention through deterrence, enhancement of peace, diminish retribution, reducing revenge, bring redress to victims. Now, you may have a question or two. Before opening the floor for questions, let me give you my rules. But before my rules, there is the fine print. And the fine print that precedes my rule is, unless I feel otherwise. Because sometimes a question appears to be totally outside my parameters, but I think, well, it's still good, and I can deal with it without creating a problem. Now, my rules are, I don't deal with politics, I don't deal with specific situations, I don't deal with chamber decisions, and I don't deal with prosecutors' policies. If you're still interested, I'm all yours.
For that presentation. It's very interesting. I'm sure there are a lot of questions, maybe even some that can fit within those rules. I have additional rules to add, unfortunately. The rule that I would like to put forward is that you please identify yourself when you're asking your question or making your comment, and that you please keep your question or comment short. No speeches, please. Starting over here.
A witness.
Thank you. My name is Said Mizai. I'm a part-time professor at the law faculty. Ottawa U. I will follow both the rules that you put for me. I worked under his chairmanship. I follow whatever he says. Judge Philippe, you didn't mention the developments concerning crime of aggression. If it comes operational one day, what do you think, whether it will add to the existing challenges of the court or it will strengthen the court? It might be difficult, but I wanted to see what are your thoughts as the architecture of the ICC. Thank you.
You always have clever questions, I know it. It's a really difficult one. It's a really difficult one. But that, of course, happened, the agreement on the crime of aggression happened after I left the ICC, so I'm a little more relaxed already about that one. The agreement that was reached on the crime of aggression, I think, makes almost certain that there will never be a case of aggression in front of before the court. That's what I think. My second thing is that this is not a point is that it is not necessarily a bad thing. The court, even with standard crimes like war crimes and all that, is already under such fire that you can imagine what would happen if it actually dealt with aggression, which is inherently political. Maybe one day, in a few decades, perhaps. But in the foreseeable future, I think the court should keep away from it. My God. My mother heard me say that.
Sentez-vous à l'aise
Oui.
à poser des questions ou en français ou en anglais? At the back first, yes.
Merci. Maître Kirsch. Mon nom c'est Jean Bosco Yakarenier. Je suis étudiant en doctorat ici à l'Université d'Ottawa et en droit. Et je suis professeur à temps partiel à l'Université d'Ottawa, justement en droit. Alors, juste une question et puis de petites observations. Ma question est celle-ci. Vous avez dit que la Cour pénale internationale est là pour rester. Et je suis d'accord avec vous que ce n'est pas demain la veille qu'elle va mettre la clé sur le paillasson. Est-ce que vous me comprenez ou bien je dois alors lever la voix?
Je vous entends très bien.
D'accord. Alors, donc vous avez dit qu'elle est là pour rester, je suis d'accord avec vous, elle ne va pas fermer demain, mais est-ce qu'elle ne va pas manquer de moyens pour travailler? Je veux dire ici, on a vu que les États africains, et quand je dis État ici, c'est en fait les chefs d'État, parce que, comme vous l'avez dit, la population est en faveur de la Cour, dans les sondages que vous avez mentionnés. Mais comme en Afrique, les chefs d'État sont comme des Louis XIV, alors ça veut dire que les États sont contre la Cour. Et s'ils se retirent demain de la Cour pénale internationale, elle va continuer à fonctionner, mais elle ne va pas trouver les clients, c'est le veut dire. Pourquoi? Parce que, comme vous l'avez dit, tous les clients se trouvent en Afrique, et ce n'est pas par hasard, c'est en raison des crimes qui se commettent là-bas. Donc, ce n'est pas parce qu'ils sont visés en tant qu'Africains. Alors, je ne vous demande pas de regarder dans votre boule de cristal, mais j'aimerais vous demander que se passera-t-il si demain, après-demain, tous les États africains se retirent de la CPI. Bien sûr, le nombre de 60 États sera toujours là, mais il n'y aura pas de matière première. Alors, qu'est-ce qui va se passer?
Merci.
Une petite observation.
Très petite, s'il vous plaît.
Oui, tout à fait. Donc, parmi les défis de la Cour, vous avez mentionné les États-Unis, qui ne sont plus aujourd'hui un vrai défi parce qu'ils collaborent avec la Cour aujourd'hui. Par contre, on a vu apparaître il y a une semaine, deux autres États membres du Conseil supérieur donc du Conseil de sécurité, donc deux membres permanents, qui sont contre la Cour de façon claire parce qu'ils ont voté en faveur de l'annulation, si vous voulez, du procès des deux présidents, du président du Kenya. les États-Unis se sont abstenus pour dire qu'ils étaient en fait en faveur. Alors, que va faire maintenant le Conseil de sécurité, qui est un grand joueur pour le forcement de la Cour? Que va faire le Conseil de sécurité pour amener les deux États, je vais utiliser un mot anglais, log states, pour ne pas dire en français le mot qui est plus fort. Alors, qu'est-ce qu'on va faire? Vous pensez que ça va se résoudre?
Merci, monsieur. Merci, c'est bien.
En ce qui concerne votre question, d'abord, je pense que vous avez tout à fait raison. On ne peut pas avoir une cour qui soit viable avec un retrait massif des États africains. Je ne pense pas que ça arrive. Je crois qu'il y a vraiment des divisions profondes, non seulement entre société civile et gouvernement, mais entre différentes catégories de gouvernement, sur le rôle de la CPI. On m'a même dit qu'il y avait une différence entre États francophones et États anglophones sur le rôle de la CPI. Le président du Sénégal vient de dire hier ou avant-hier, vient de faire une déclaration très en faveur de la CPI. Et je pense que, de façon générale, ce sont évidemment ceux qui sont le plus hostiles, qui parlent le plus fort. Je ne pense pas que ces gens constituent une majorité. Cela dit, je pense qu'il est essentiel que la Cour rétablisse, reconstruise les ponts qui ont été brûlés. Et je pense que c'est un peu tard aussi pour le faire. Je pense que c'est quelque chose que la Cour aurait dû regarder il y a plusieurs années et déjà prendre des mesures pour qu'il module un petit peu mieux son intervention et qu'il n'y ait pas que des pays africains. Que ce soit légitime sur le plan des procédures, je crois que c'est le cas. Je pense qu'effectivement, la gravité des crimes, la façon dont c'est géré est compatible avec le statut, mais ça donne une très mauvaise image de marque à la Cour de ne traiter qu'avec des pays africains. Donc, je pense qu'il faut absolument que l'Assemblée des États parties cette année s'y mette et que ça continue, un processus de reconstruction qui redonne à la Cour, je ne dirais pas une légitimité, parce que la légitimité de la Cour ne vient pas de sa popularité, la légitimité de la Cour vient de la façon dont elle se comporte. Et son comportement donc doit être absolument judiciaire et conforme à son statut. Mais en termes politiques, la situation actuellement est très mauvaise et il faut que la Cour y travaille. Ou du moins que les États y travaillent si la Cour elle-même judiciaire ne peut pas le faire.
Philippe Kirsch, ancien diplomate canadien. La situation la plus difficile en situation post-conflictuelle, c'est évidemment la réconciliation. Et dans quelle mesure est-ce que l'existence, la contribution et le rôle de la Cour pénale internationale peut avoir aidé ou au contraire nuit au processus de réconciliation nationale dans les différents conflits qui ont été apportés à la Cour?
Ça, c'est la question la plus difficile qu'on peut poser. Merci beaucoup, Philippe. J'apprécie. Je pense que ça varie de situation en situation. L'expérience montre que si on laisse une situation d'impunité perdurer indéfiniment, ça ne donne pas de bons résultats. On l'a fait au Sierra Leone et un conflit qui était terminé, c'est tout d'un coup, les crimes ont recommencé. Mais il y a des cas où je pense qu'il est effectivement peut-être sage d'attendre un petit peu avant de commencer des procédures que la situation se stabilise un petit peu. Je ne pense pas qu'il y ait les juristes, les vrais juristes, là, pas moi, là, les vrais juristes vont dire pas d'impunité jamais. Moi je trouve qu'il faut faire attention à ça. Je trouve pas d'impunité jamais, d'accord, mais pas nécessairement tout de suite. Il faut quand même comprendre un petit peu de quoi il s'agit. Une fois que quand le procureur se saisit d'une affaire, là c'est un train en marche. Parce que le procureur va chez les chambres vont prendre des décisions. Et les chambres ne vont pas prendre de décisions sur l'opportunité de mener des procédures, ce que le procureur peut faire, mais sur la qualité des preuves, etc., qui sont apportées dans tel. Donc, pour moi, le procureur a un rôle extrêmement important dans tout ça. Mais je n'en arriverai jamais à dire que l'impunité... L'argument que l'impunité devrait exister est un argument qu'on n'entend plus beaucoup. C'est l'argument qu'on entend maintenant. Est-ce que c'est le moment? Quels sont les outils? Quelle est la séquence? Et ça, c'est une avancée remarquable dans les 20 dernières années. Pour la question de la dissuasion, qui est une espèce de codicile, voilà, merci Philippe, merci. Le codicile à cette question, quand j'étais président de la Cour et que je suis allé aux États-Unis, aux Nations Unies, j'ai eu des conversations avec deux sous-secrétaires généraux en charge des opérations de maintien de la paix de suite. Donc il y avait le prédécesseur et le successeur. Et ils m'ont tous les deux dit, certaines milices dans certains pays ont arrêté de faire des choses, commettre des crimes, parce que, par exemple, le Lubanga avait été arrêté. Donc une autre milice a décidé de cesser d'employer des enfants soldats parce qu'on voyait bien que ça menait à des résultats désagréables. Et je parle des enfants soldats, mais je parle d'autres crimes aussi. Maintenant, est-ce que c'est tangible? Non, c'est pas tangible. Comment est-ce qu'on peut prouver que quelque chose n'est pas arrivé? La raison pour laquelle quelque chose n'est pas arrivé. Donc je ne pense pas que l'effet de dissuasion à l'heure actuelle soit un effet puissant, mais je pense qu'il a commencé. Et après tout, la Cour pénale est vraiment dans son enfance. Elle ne fait que commencer. Alors je pense quand même qu'il faut... Je vais vous citer Chouenlai. Vous allez aimer ça. Chouenlai, un jour, on lui a posé la question... Oui, bien sûr. On lui a posé la question... Chouenlai, pour ceux qui sont trop jeunes pour le savoir, était le ministre des Affaires étrangères de Mao Tse-tung. Et on a posé à Chouenlai la question, que pensez-vous de l'effet de la Révolution française? Et il a dit, c'est trop tôt pour le dire. Voilà.
Thank you very much, Professor Kirsch. My name is Wael Abulmagd. I'm the ambassador of Egypt here in Ottawa, and I perhaps as one of the witnesses that you alluded to earlier on, who was part of this process from the very early days. Your most striking point, which I fully agree with, is the reference to the fact that the blurred line exists between what is political and what is legal on all issues of public international law. So it is very difficult to abide by your requirements not to bring up anything political, but really this is an objective question, because I precluded like 6 issues I wasn't going to touch right now. But really, would you find it completely unjustified, the perception that exists amongst many people in developing countries in particular, including in my own, where we were very enthusiastic, very supportive of the ICC from the moment it was, the statute was given to the ILC to draft and later on? That there's this sense that only certain categories of countries or government officials will be brought to justice before this newly very hopeful court, and certain categories of officials in various other countries will not be brought to justice before the court. So there is this element of politicization, at least in the perception of the general public, that continued to be supportive. And another challenge for the future, because we still continue to aspire to a very effective court in the future, pertains to universality and acceptance by various countries. You didn't mention the word Article 98. I don't know if that crosses the line of political, but these Article 98 agreements, so I'll leave it up to you whether it is categorized under the prohibited or not. Thank you very much.
I'm sorry, but what about Article 98? I cannot pass judgment if I don't hear what you are saying about.
Well, the article, everyone's familiar with Article 98. Okay, okay. Well, I'll leave it at that, and I'll leave it up to you.
Okay, not having a question on Article 98, I can't answer it. But it is true that there is a perception of double standards. That perception of double standards is in some ways real, in the sense that a permanent member of the Security Council, for example, in all likelihood will never, whatever happens, will not find itself before the court. I say in all likelihood because there's a bit of a bémol here, there's a bit of caveat. There is a provision in Rome Statute that says that if people from state A commit crimes in state B, even though state A is not a party, the court still has jurisdiction, which is, at least in principle, a very important provision. So it is not excluded that even states that appear to be outside untouchable are really untouchable in all circumstances. But of course, the political reality is that, yes, you have states that will be more vulnerable and other people which will be less vulnerable. Some of it is objective, as I said, because it's a matter of jurisdiction. The ICC cannot go beyond what is permissible. Some of it is avoidable, and that would be an approach, for example, by the prosecutor, which is visibly even-handed in situations as to who is targeted, and take on situations that have not been taken on yet. Before starting this tour, I looked at a document prepared by the prosecutor on those 8 situations under preliminary examination. Because I wanted to know why none of those 8 situations were being dealt with. And the answers were variable, but basically they were, we see signs that they are trying to apply their own system. They would say that about Colombia, for example. Or they would say, or the prosecutor would say, we don't have enough information because we don't get any cooperation, and things like that. There were always reasons for not doing something. And I find that strange. It seems to me that one or two situations out of Africa should come to the ICC to show visibly, clearly that no, it is not. That all this propaganda against the ICC as being racist, which is not founded in that way, but it can show visibly that no, it is not the case, that the ICC is going after other situations. So double standards, yes. Complicated reasons, there should be an end to it. What did I say?
Outside of Africa.
Outside of Africa. Not only Latin America, there are other bad people.
Pacifique Manirakiza, je suis professeur à la faculté de droit. Et je vous remercie pour votre présentation. J'ai un commentaire puis une question. Je vais d'abord, disons, faire le commentaire avant de poser la question. Je pense que un des grands défis de la Cour pénale internationale, c'est vraiment la manière avec laquelle la Cour va être en mesure d'établir un équilibre entre la paix et la justice. Ça, c'est quelque chose de très, très primordial. Surtout quand je me réfère à la situation que vous avez pris pour cas d'étude, la situation du Kenya. Et cette situation a changé vraiment ma conviction des choses parce que au moment où il y a eu l'attaque terroriste du Westgate, j'étais à Nairobi, j'observais ça après, j'étais dans un hôtel qui était tout proche de l'affaire. Et en même temps, dans ma chambre d'hôtel, j'observais les audiences à la Cour pénale internationale, où le vice-président était en train de suivre son procès pendant que le peuple qu'il a élu était en train de demander de l'aide. Et non seulement ça, la Cour voulait encore que le président rejoigne son vice-président à l'aide. Donc, je pense que dans une situation comme pareille, où le Kenya est en pleine guerre contre le terrorisme, à la fois à l'interne et à l'extérieur, je pense que la Cour devrait prendre le dossier et puis agir en conséquence. Si cette situation se passait au Canada, je pense que le Conseil de sécurité réagirait autrement. Et si cette situation se passait dans un autre pays que le Kenya ou autre, je pense que la situation serait différemment analysée par les académiciens, par les intellectuels et aussi par les décideurs. Ça, c'est mon commentaire. La question, je sais que vous êtes au courant qu'il y a un nouveau développement en Afrique, où l'Afrique va mettre en place bientôt une sorte de ces pays africains, en étendant la compétence de la Cour africaine des droits de l'homme et des peuples pour qu'elle soit à mesure, soit dotée d'une compétence pour juger les crimes de guerre et les crimes contre l'humanité. Qu'est-ce que vous pensez de ce développement? Merci.
Merci. Je vais faire un commentaire sur votre commentaire quand même, parce qu'on ne fait pas des commentaires gratuitement comme ça. J'ai déjà dit plus tôt que j'étais favorable à ce qu'on revoie les modalités de participation des accusés qui sont dans des positions aussi importantes, qu'il doit y avoir un moyen de ne pas obliger les accusés à être là tout le temps. Donc moi je suis très favorable à un accommodement sur cette question-là. Évidemment, la situation au Kenya a commencé, elle ne peut pas être retirée de la Cour par la Cour. Les procédures sont en cours, le train a quitté la gare, et puis ça, c'est comme ça. En ce qui concerne la Cour africaine des droits des peuples, il faut que... D'abord, on a quand même assez loin de sa transformation en Cour pénale. Hein, bon. Mais supposons que ça arrive, à ce moment-là, ça dépend comment elle fonctionne. Il faut que son fonctionnement soit équivalent à ce que ferait l'État, l'État où se déroulent où il y a des problèmes, pour qu'il n'y ait pas d'impunité qui en résulte. Pour que ce soit l'État, via ce mécanisme, qui montre qu'il est capable et qu'il veut mener des procédures authentiques. Si c'est le cas, à ce moment-là, c'est une façon d'exercer la compétence nationale, comme ce devait être le cas. Mais il faut que le mécanisme soit bon. Il ne faut pas que le mécanisme serve de prétexte à oh, ben, finalement c'est pas si grave que ça, on les laisse aller. C'est ça le danger. Et c'est pour ça que je suis tellement, je trouve tellement désagréable cette fusion de politique et de judiciaire. Parce que rien n'est plus rien. Là. On n'est plus très sûr de ce dont on traite. Et donc, réponse à votre question, oui, bravo, pourvu que ça fonctionne bien.
We're almost out of time, and what I'd like to do is take a couple of questions in the last round, and then give you a chance to respond to those and make any closing comments you might want to make. David, and then is there anybody else who wants to ask a question in this final round? Or is David going to get, okay, and then one other question back there. David, please.
Okay, I was going to ask about the interest of justice and the prosecutor's policy, but you ruled that out, but I pose it anyway simply because you've hinted at a couple of other, in your responses, that maybe it's not out of bounds. You said there was some room for maneuver.
Just ask it anyway.
The question, had I asked it, would have been whether the interests of justice, as interpreted by the prosecutor in the current policy, is, in your view, sensible or might be widened in future revisions. But the question I really want to ask you is about the Security Council and their referrals, because you hadn't ruled those out. And the question here is, I've been speaking with different people, mainly kind of human rights advocates, who always saw the possibility of Security Council referral as potentially a good thing, because it allowed states which hadn't ratified, the court would have jurisdiction, Sudan, Darfur, Libya, and now, of course, the argument over Syria. But recently, I've detected a change of tone, and in fact, in the wake of the Sudan and Libya referrals, a kind of a sense, hard to pin down as concrete yet, but a sense that perhaps these Security Council referrals are actually not such a good thing, and maybe doing damage to the court by increasing the perception, not the reality, but the perception that the court is exercising a political function.
And let's take, before you answer, one more question, please, sir.
My name's Aubrey Morantz, and I'm with the Africa Study Group of the CIC. My question, in fact, is almost identical to the question that was already put. In fact, we had a distinguished jurist here a little over a month ago who said that the referrals by the Security Council are problematic because they're a complete betrayal of the rule of law. And I think the idea was that because members of the Security Council are obviously political, it's a political body, three of which, of the five of which have not ratified the Rome Statute, it's inadmissible for them to be putting cases to the ICC. So basically, that was my question.
Aubrey, that is a highly political question. Any decision of that kind to trigger, say, a body like the ICC is a political decision, of course. It's true what you're saying, that there are different situations. It is also true that, as I was saying earlier, in certain situations, any one of those permanent members could be brought before the court in certain circumstances. But that is the political use that is made by a judicial body ultimately, what counts is how does the judicial body behave? You saw a few years ago, say, lawyers bringing a case or attempting to bring cases to the ICC because the subject matter of those cases would end up putting X or Y state on the spot. And the prosecutor did not take those cases. Therefore, they did not go to the chambers because they were saying, no, here we become political. This is not our role. We have to stick to really judicial proceedings. But the fact that this political decision is taken, whether it's right or wrong in this case, I'm not going to pass judgment, but the fact that a wrong decision may be taken does not mean that the court ceases to be a judicial body. The day it ceases to be a judicial body, then it should disappear. But as long as it is in legality as opposed to legitimacy, as long as it is in legality and it complies with its mandate strictly, then one should not blur political and judicial.
Well, thank you for the reply, and I'd like to call upon now my colleague David Petrasic, who's an associate professor at the Graduate School of Public and International Affairs, to close our session.
Okay, thank you, Roland. Thank you, Judge Kirsch. Maybe I'll just close very, very briefly, maybe just with 2 points. The first is in the 1990s, I was working on issues of international human rights in the NGOs and in the United Nations, and I can remember very clearly, I can't remember the date, but I'm sure it was sometime 1997, early 1998, where the word came down that you had been appointed the chair of the forthcoming Rome conference at a time when many were very unsure of what the result might be at the conference. There was a lot of anxiety, in fact, that things could fall apart or that we could end up with a statute which didn't give the prosecutor the independence you mentioned. And I distinctly remember the audible sigh of relief when it was announced that you had been given that position, because people knew that you would manage to make this work, and your role there was really instrumental. So thank you for that. Thank you for your talk today. I think the second point I'd make is about the challenges you mentioned. It's really, for me, what I took away is the time. The courts had 10 years. We had 50 years between Nuremberg and the Rome Statute, and we can't expect to see in these 10 years all of the results we'd hope for so quickly. It's going to be a long, hard slog, but thank you for starting us off on this path and for your contribution. So, thank you very much.